Hello and welcome to another lecture of the Law of the Sea. I'm Muhammad Tahmidul Islam, lecturer, Department of Law, World University of Bangladesh. And today I'm going to talk about carriage of goods by sea. The law of carriage of goods by sea is a body of law that governs the rights and duties of shippers, carriers, and consignees of marine cargo. Globally, the UN Convention on the Carriage of Goods by Sea, 1978, is acceptable as the general international law to be followed by all nations. In Bangladesh, we have the Carriage of Goods by Sea Act 1925, containing 7 sections and 1 schedule in total. The party responsible for shipping the goods is the shipper or consignor. This would usually be the seller. The consignee is usually the buyer and is the person named as consignee in the bill of lading. The term endorsee or endorsee means a subsequent buyer, also known as a person who buys the goods by an endorsement made by the buyer or consignee on the bill of lading and the delivery of the bill of lading from the consignee to him or the endorsee. Either of them may be entitled to deliver of the goods by the carrier or the ship owner. The shipper or the seller frequently employs a forwarding agent and the ship owner or the carrier a loading broker. The forwarding agent usually has to ascertain the date and place of sailing, obtain a space and fill in the bills of lading indicating the name of the consignee or the buyer or person to whom the goods are to be delivered or endorsee. The typical obligation of a carrier by sea to a shipper of cargo are to provide a seaworthy ship, to issue a bill of lading, and to properly and carefully load, handle, stow, carry, keep care for and discharge the goods carried. To proceed with reasonable dispatch, the duty of a common carrier to convey goods from shipper to consignee with all reasonable speed. The carrier, however, assumes no obligation for loss of market or other losses sustained as a result of delay in transit, and to follow the agreed route and not to deviate from it. So, in this lecture, we have talked about the basics of shipping, and we have also talked about the obligations of a carrier, which is one of the most important things. All of these legal issues that arise from the international transaction of goods and services, in that place, the ship owner and the carrier has a huge responsibility. So, what are those responsibilities? From A to E, there are 5 main responsibilities that the carrier has. Number 1 is to provide a seaworthy ship. The ship must be seaworthy. The ship must be capable of um, transporting the good. And the carrier is also responsible to issue a bill of lading, which is a document that has to be issued, the document that has all the description of the ship and of the cargo, and to properly and carefully load, handle the goods, and to store the goods, and to proceed with caution when dealing with the product, and also to follow the agreed route. So, if a carrier follows these rules, he or she has no problem. But if a carrier deviates from any of these rules, that carrier will be personally responsible, or the company will be responsible for the damage of goods. So, I hope you have understood the lecture content, and if you face any problem regarding understanding the lecture, please contact me through email or through messaging in the comment section. I will answer accordingly. Thank you so much, and I hope to see you all in the next class.